Okay, I have to talk. Okay, great. So I'm supporting this position. So my premise is that any piece of evidence that could be used in or during a jury or trial should be used, even if it's not 100% valid, or even if there's a chance that it's going to be invalid. Like, for example, witness testimonies are not always guaranteed to be true, even though they are swearing an oath. They could be lying. There's always a chance of that, but we still use that as a way to judge whether someone is guilty or innocent. So similarly with a lie detector test, it is simply a set of psychological indicators that are being used to determine whether someone is guilty or innocent. So it is kind of up to the jury, as it is always up to the jury, to make the decision on whether those indicators are valid or not valid. So it's just, again, another piece of evidence that can be used. It doesn't necessarily mean that it is 100% accurate, and it would not be used as a way to determine with 100% accuracy whether someone is guilty or innocent, but it is just another piece of information that can be used.
Lady Justice is blindfolded to hear. The integrity of the courtroom is to not to compromise the right to equal representation under the 14th Amendment, unreasonable searches under the 4th Amendment, and a fair and speedy trial under the 6th Amendment. Because the goal in the courtroom is winning, beyond a reasonable doubt, and it's more than a game with the burden of evidence, I ask you to deny the resolution lie detectors should be used to support the legal process in court, and vote con to provide the most honesty to a challenged legal process. We must ask two questions to weigh the overall value and burden of evidence. 1. Are the tests scientifically accurate? 2. How would they help the legal process today? 1. The National Research Council and others have called into question the accuracy and validity of these tests, stating evidence is scanty and scientifically weak, in the opinion of 2/3 of the scientific community. It is impossible to measure human activity in this way that would either show a person is lying or prove a test to be valid, reports Forensic Science magazine. And studies from the University of Haifa show these tests are only accurate 60% of the time, rather than 90% of the time, as claimed by the American Polygraph Association. That creates a false positive in investigations, as the BDC reports. Specifically, the American Psychological Association recommends against their use in the courtroom, as psychologist Leonard Sachs, PhD, professor and polygraph researcher at Brandeis University explains. Because of the nature of deception, there is no good way to validate the test for making judgments about criminal behavior. There is no unique psychological reaction to deception. These tests can be fooled and make mistakes. Due to uncertainty, the test-error ratio projects bias. Other research shows the test can also give false results when a person is nervous. Now, I do have more about the legality, but that I can't do that in 3 minutes. So I'm going to go ahead and throw out a contention to your statement. Any piece of evidence that could be used should be used. According to the Supreme Court, it's not a piece of evidence. It's an opinion. It can only be used to influence the overall perspective of evidence that is presented. So it's not a physical piece of evidence. So it's not like a fingerprint. It's not like a tire mark. It's not like any other form of forensic evidence. It is defined as an opinion. And as I will illustrate later, the Supreme Court also has the burden of deciding what expert testimony and opinions are accepted. And if you have, and as they cite, if you have 2/3 of the scientific community saying this is not science, that is not admissible in court as science. It does not meet the burdens of evidence, and it is.
Well, just to address the last statement right away, I use the example of witness testimony, which is not a scientific piece of evidence either. That is also someone who has been called to the stand to sometimes just give their opinion on a situation without even necessarily saying, do you, at this time, were you this, were you that? Even though if they were somewhere or if they were not somewhere, if they're answering a question as to whether the defendant, was doing something or was not doing something, although they are saying that, and sometimes hopefully as fact, that it's not necessarily a concrete piece of evidence is what they're saying. So, they could be lying. It's not 100% true. So again, not necessarily a concrete piece of evidence. But again, as the accuracy, I'm definitely not disputing that these tests could be inaccurate or even likely to be inaccurate.
not sure what happened there, but I'll just go ahead and continue. This is exactly why the Supreme Court is right to restrict across the board these tests in federal, state, and military courts for not meeting the burdens of applicable evidence time and again, for the same reasons lie detectors are restricted for the practice of job applicants. Lie detectors are opinion testimony. Since Daubert versus Merrill Dow Pharmaceuticals ends, federal judges have had the responsibility to act as gatekeepers of the scientific testimony through a two-pronged test to determine whether an expert's testimony both rests on a reliable foundation and is relevant to the task at hand, and not based on the expert's conclusions, but on the principles of methodology. So it has to be based on actual evidence, not the principles of a method. You're testing a method. You can't bring that into court. Most state courts now use either Daubert test or the older test from the Frye versus United States, requiring general acceptance by the relevant scientific community, which 2/3 of don't agree with this. So that's not possible. The United States first, Schieffer recognizes the National Research Council's decision as an unwarranted search, which it is, that involves the opinion of an outside party. This tampers the right to a fair trial and fair and equal representation. Furthermore, that decision cites a liability for the state because false testimony has potential damages and would open the courtroom to other outside opinions. Lie detectors cannot help the legal process because they are not legally valid as science and directly violate constitutional protections concerning fair and due process.
Well, I think that is something, an important point you brought up, that they're, just again, another piece of evidence or another opinion. But the thing is that these are not, conclusive in terms of, witness testimony or, like you said, when someone's testimony and they could be lying, it could be wrong. It's, it's false. It's not good. But the thing is, the more pieces of evidence, even if they're not, necessarily fact-based in terms of their interpretation, because you could have a piece of evidence that could be interpreted a number of ways. So just because something is supposedly a fact or a concrete piece of evidence, it's not necessarily, definitive in terms of, or conclusive in terms of determining their innocence or guilt. So in terms of lie detector tests, just getting even further, more scientific evidence. But no, this is what I was going to say. I totally forgot. In terms of using these pieces of evidence, you said letting these pieces of evidence be exposed to a jury. A jury is larger than just one or two people that are judging these things. So the jury, in terms of being able to see these evidence, it's more people that are seeing these psychological indicators, because usually in questioning, only the cop or only the questioner is being able to see the pieces of evidence that are, in support or in denial. So allowing the jury to see the results and see these psychological indicators is letting more people ultimately decide the fate of, a defendant, rather than just one police officer who is determining whether the psychological indicators exhibited during questioning are accurate or inaccurate.
What you're missing there is that a judge would have to let that evidence into the courtroom to begin with, and the rare examples where it could be used. But I think the big contention here is that it's a false positive. So let's look at how the BBC reports that this is how the BBC connects this to terrorism. The BBC claims that if you have 3,000 terrorism suspects, and we're just going to go ahead and claim it's 90%, not 60%, like the University of Haifa says, and that the American Polygraph Association says that they say themselves it's 90%. So we're just going to assume that's 90%. So you have to arrest 300 people out of these 3,000, and then out of that you'll have one possible terrorist. So you have to 300 people. You have one possible terrorist. So that means even that this jury is going to be asked 1 out of 10 times. This jury is going to be asked to rule against somebody, and they're going to have evidence that's potentially convincing. That could be an innocent person. That could be that insurance company that just doesn't want to settle. Now you're really up up the creek because they have one more thing they can just throw at you. So it's really not in any interest of the little guy at all. And you know, you have to remember that a jury, they also have to totally agree with each other. All right, it's a mistrial. So all you have to do, so say you're a defense attorney, and I mean, it's in a defense attorney's best interest because they have to say they did everything, and you know, they're trying to create doubt. So what better than to create doubt than I have this thing that says that maybe so-and-so was lying. So you convince this one person now that maybe it's lying. You can throw the trial off. So as the Supreme Court has ruled, it's a burden of it's not a sufficient burden of evidence. It's just an opinion. It's not like if I had some sort of physical object at the crime scene or anything like that I could show the jury. I'm bringing someone's opinion in, and that's actually also violates constitutional rights because I'm subjected to this search. You know, if it was an investigation, I could say no because it's a search I'm being submitted to, and you're bringing in an outside person's judgment, and that's a violation of the 14th and 6th Amendments. So there's no legal way. It's not science that can be recognized by the court. It would influence the jury they can potentially influence the jury in a way that's misleading, and in a way that's misleading. So I think there's a lot of reasons that you're just missing there.
Well, there's one thing that you said, though, is opinion. I think I take issue with that just because it's not based in opinion. These tests are literally psychological indicators. So it's not, just a total opinion. Like maybe it's not 100% accurate, but the indicators or the measures that are being measured are still accurate. You know, that person's heart rate, their level of, how much they're sweating, where they're looking around, how they react, the number of seconds that last before they answer these questions. Those things are all concrete and fact-based. Those are all psychological indicators that are measured, and those are facts about how they're answering the question. Now, the results, I think, are questionable. You say, oh, so this means this and this, this. That is subjective. But the question now is just, should lie detectors be used to support the legal process? So it's not saying, should the lie detector, conclusively saying that it's yes or no, or if they're lying or not lying. That's not what the question is. The question is, should the lie detector, the lie detectors test themselves, the information that we can gather from the lie detector test, should those be used in court? And so in terms of that, those are concrete fact-based and pieces of evidence that are used in court. Those are science-based. So, to answer that. And then again, you said that, just one person could throw the entire thing off. Well, that's just, general with any trial. If one person is seeing one thing that the other people aren't, then that could also throw it off. So that's not something that's unique to lie detector tests. Lie detector tests, or the information that can be drawn from lie detector tests, are simply pieces of information that are letting the jury, not only the jury, but the judge as well, make a more definitive conclusion, and everyone just, access to more information, how someone's answering some question. They could even be used positively if someone's answering a question and they seem to just be so nervous and just like breaking down and, not able to answer the question succinctly or honestly. Maybe they're just overwhelmed. It's just another piece of evidence that can be used. And so the whole point is to determine the accuracy more efficiently. And so I think that the more pieces of, again, concrete fact-based indicators that we can use to judge whether someone is guilty or innocent are ultimately going to help the legal process. It's just giving the jury more information to use to make their decision. And I think that, again, the more information that's available, the more accurate that decision is ultimately going to be.
The reason that it can't, so it's not meeting. Well, okay, I'll go ahead to your contentions actually first. By saying that it's not conclusive, it's just something else you can throw in there. I think you're really missing the point. You're just kind of jumping from A to B, and B, especially by saying, when you say something like anything could throw the trial off. That's the whole idea, is that I don't want to put someone else's opinion in. I'm violating their 14th and 6th Amendment rights by adding in someone else's opinion as opposed to just what the person's saying. So I'm giving them this extra burden of evidence. So you're totally missing that. And this idea that they're not conclusive, that's the whole reason that they're not allowed in the court in the first place, and that the court defines them as opinion testimony. And and as I've already stated, the reason that the American Psychological Association says that they should not be used in court is because they're deceptive, because they can be used for deception. They can be thrown off. And psychology tells us that we can lie to ourselves. We can trick ourselves. So we can fool ourselves. The person is going to say what they believe. They're going to convince themselves that they can believe that. And this whole thing with expert testimony started where this Dow trial is where both sides had expert testimony, and the court had to decide what was science and what wasn't, and that's how they've set. That's why they've set these standards that you can't that it's opinion testimony. So you're opening up this whole Pandora's box where other forms of opinion testimony can be let in as well, and then you also have to consider that it's a liability, because what if that person is lying? Now that attorney or that court, they're liable. They can be sued for that. So no, I think it's very important that the science isn't conclusive. That's the reason that they shouldn't be used. And of course, this is also supported by the fact that it's just plain illegal under the Constitution. And other studies also show that it's deceptive. But the one I would point to is that it's from 2011, the Forensic Science magazine saying that you can't. There's no way to measure someone's body actions that they're really lying or not. Because for one, we can't decide the weight of a lie. We can't decide how big is this lie that they're telling. Okay, there's no way to measure that, right? Unless the person is completely still, there's no way. There's no way to weigh it against other factors that could be influencing their movement, which we know if they're in court, they're probably nervous, and that's one of the things that would throw the test off.
Okay, yes. So anyway, so you say again, like, the fact that they're not conclusive is the reason why they shouldn't be used. But again, it's not necessarily saying, though, even though the test itself isn't conclusive, it's not like the people who are interpreting the results are also going to believe that it is not conclusive or that it is conclusive. So someone who sees the results of this test, just because the interpreter said that the indicators that the subject demonstrated were conclusive or that led them to believe that they are guilty or not innocent, the jury is not seeing these tests necessarily thinking that they are guilty or innocent. In fact, most people do recognize that the lie detector test is not conclusive. So people recognize that the results are not going to be necessarily accurate. So basically, they aren't looking at these tests saying, okay, well, the lie detector test said that they are lying, so therefore they are being convicted. Like, it wouldn't work like that. That's not how the test would be used in court. It's, here's the results that we garnered from our test. Now here, it's up to the jury to use the results that we got from these tests, again, to make their decision as to whether, someone is guilty or innocent. So again, I don't think it's necessarily saying that just because the test said that this person's lying, it means they're lying. That's not the impression that the test would be used under. It's not necessarily saying that, yes, the test is conclusive. Yes, the test is not conclusive. So then therefore the person is guilty, therefore the person is innocent. It's just, hey, when they were answering the question, this is what they, appeared to be like. And I feel like that's just something that is available even without using the test. Even when someone is sitting at a stand being questioned, the jury, can see the defendant there. So then it is up to them, that's information that they're using. So just to say that, like, no information is used ever, that isn't necessarily fact-based, like, that's just not true, because you can see that the jury is swayed by other factors other than facts. The jury is swayed by emotion. The jury is swayed by, even though juries are accumulated and gathered in order to be as accurate and as unbiased as possible, there's no way to completely filter out these biases of the jury. So even though someone, appears to be neutral and not influenced by other opinions or opinions that would be not fact-based, they still are. I mean, it's impossible to totally filter that out. So again, just providing them with, like, more information that they can use to make this decision is ultimately going to lead to a more accurate, I think, decision at the end, just more factors, because saying, okay, the jury is only using these 2 factors to determine whether someone's guilty or innocent. I think that the more factors available, the more factors it should be used. Like, regardless of, if the test, again, is accurate or not accurate, the more factors that can be used should be used. It just makes sense to give the jury the most possible information to eliminate the effects of these biases long term.
You assume that the person who's giving this test is I believe is that it's more likely that they're going to say what they're being paid to say. So if the state's paying them to say that so and so is guilty, they're going to say that. And if so and so is paying them to say that maybe that they weren't lying on the stand and that there's some reasonable doubt, they're going to say that. It's a whole industry, and there's no way. There's just we know that there's ways to throw off these tests. There's no way for them to be completely accurate. And if something's not completely accurate, then what good is it? Okay, so if this you're saying as juror, they're gonna have this idea that maybe it's not completely accurate in the back of their mind. What good is it if it's not completely accurate? So they're going to be told that it's completely accurate if it is or isn't. So we're assuming things, and the jury, they might see somebody testifying on the stand to see how nervous they are with what they're doing, how they say something, but they are not. They can't see them take the test, right? So there's a big difference there. So why take something that's unbiased and throw something in there to make it biased? As I say, Lady Justice has to be blind to see, or has to be blindfolded to see. She's wearing a blindfold for a reason. You can't just make her see your way. She has to hear and decipher that way. And the only way for her to hear and see accurately is on the stand and in the courtroom.
So yeah, just one thing you said though that I was, pushing about. You said they'd be paid to say the test was accurate or not. I would hope that if these tests were being used in court, the court wouldn't be corrupt enough to where whoever is administering the tests or giving these results is going to be being paid like that. I mean, and that's an argument that can be made for anything. Again, I hope the legal process isn't being influenced by people being paid to say certain things. That's like saying the judge is ruling the case is, or that a defendant is innocent or guilty because the judge is being paid to say that. So I feel like, anyone that's coming into court is, under oath. And again, I said that witness testimony could lie, and they could. But in terms of this, I don't see the motivation. You said they're being paid to say the test a certain way. I don't see why they would be being paid. I feel like they're being paid to administer the test accurately. And I'm sure that their tests, or there's, could be checks in place where it's just not one person that's administering this test. I'm sure there'd be kind of like a chain of command where someone would administer the test, someone is checking it. It's not just, I don't think it's just one person that's saying, oh, this is what I got. And I'm not going to let you see my data, but this is what I'm saying. Like, obviously it's scientific. There's going to be someone that's there checking the process throughout. I don't think that it's going to be as easy for the test to just be like, yeah, we're lying. We're making this up. This is false. But, we're just being paid to say this. Like, who would be being paid them? Why are they paying them? What motivation do they have to be being paid? So I feel like that's not necessarily, an accurate judge of whether lie detector tests or the information that's being gathered from lie detector tests as being judged to be accurate or inaccurate. So I feel like it's, just important that we realize that it's not just the test, like it's the information that is used to make the test. Like, it's not just a statement, yes or no. It's a whole range of psychological indicators that, again, are not based in opinions. These are rates of, the person's heart rate, the person's where they're looking and things like that, how fast or quickly they're breathing. Those are all measures that can be used and that are based in science and based in studies and using scientific equipment. So that, in my opinion, is not opinion. That is just more, that those are more fact-based indicators that, again, could be used. And again, it's not to say that they would always be used in the favor of, in the same way that they would be inconclusive or not conclusive. But again, going back to that, I think they're fact-based indicators that would not be influenced by people paying them to say certain things or manipulate the facts. I feel like, the facts are the facts, and the more facts that can be used to make the decision, the better.
In the legal process, people don't work for free. So it doesn't matter if it's the prosecutor, the judge, the jury, the courtroom, they're all there to make money. And so this person is selling this, they are going to have someone call them because it's going to go in their favor. And let's go back to that example of the police. They're highly trained to be convinced in court. Their whole job is based on the number of convictions. They're more likely to be able to pass this test. So you're putting the witness in a position where now he has to pay out of his own pocket for this test. So it's a lose-lose. and then you say the judge decides who's guilty. As we already know, and we already said the jury decides. But we actually have a really strong example analogy here, and that's breathalyzers. Breathalyzers are not scientifically accurate, and it's been proven that they've had to recall cases on interlock breathalyzer because as sure as that someone blew into it, it blew super high and they got convicted, and they've actually had to overturn convictions because of this interlocks breathalyzer. And so the police officer, his job is to convict you, which sounds good, but and the thing is, in court, he's more likely to lie. The company that's selling the breathalyzer, it's more likely to be marketed on convictions. And then you go on. Now you're trying to claim. Now you're using that, trying to say that the accuracy is on your side. But as I've already said, the American Psychological Association says that people will be deceptive, especially a criminal or an insurance lawyer or somebody like that. And Forensic Magazine says that there's no way, there's too many variables unless someone's sitting completely still. There's really no way to measure their heart rate and their movement in an accurate way to tell if they're lying or not.
So yeah, anyway, you used the example of breathalyzer tests. I feel like breathalyzer tests are used often to convict people, or not even necessarily used to convict people, but when someone is driving and they get out of the car and blow whatever number, that's an indicator, or that's a physiological indicator that is used to determine whether someone's guilty or innocent. And I feel like breathalyzer tests, yes, there are shown to be inconsistencies or inaccuracies with using breathalyzer tests, but I feel like for the most part, that's what police rely on to determine whether someone, when they're driving is, intoxicated or not. So I feel like that is actually used more accurately than not. Again, all of these things are imperfect. So regardless of what we're using, it's not like it's going to be able to ever determine with 100% accuracy. But again, it's up to the jury to decide. And when I was talking about the judge example, I wasn't saying the judge decides, but I was just saying like him using the judge as a figure in the process that would hopefully is not being biased or being paid. And again, you said that no one works for free. Well, yes, that's true, but they're paid in order to hopefully be accurate. And again, there's corruption and things like that. But in a case like this, hopefully we'd be able to separate that and make that an independent, reason as to why someone's being judged, to be guilty or innocent. So hopefully it's just, again, another indicator that can be used separately.
The interlocks lawsuit is real. It's a very strong illustration of how this evidence can be used wrongly. I'll just go ahead and finish. You have not answered how this would be scientifically valid to enter into court, or how they do not violate the Constitution, and how they would not be a liability. The justice is blindfolded for a reason she does not see her.
Well, yeah. So again, they're not necessarily used, to say, we're not using these tests to say whether someone's guilty or innocent. We're using these tests to provide the jury with a greater number of indicators for which they can with which they can use to make their decision. And the more information the jury has, I think the more accurate their decisions are ultimately going to be. So I think that's the goal of this would be to provide more indicators.